estate planning is an important and everlasting gift you can give to your family, and setting up a smooth inheritance isn't as hard as you might think. But this really is, it's not a language we learn in school. And so the wills and trusts and powers of attorney, and we talking about the trustee or the executor? Are we talking about the beneficiary or the grantor? And these once you understand the basics of how it works, it really is not. I agree with Susie. It's not as difficult as we might think that it is. And so let's hit some basics tonight. First of all, the reasons I like to have an estate plan created is, number one, you stay in control of the assets. Number two is you can protect yourself from unnecessary stress, conflict, court involvement. I like the idea of passing on and not having attorneys involved. I like the idea of keeping family matters family, or family matters private. Those are important things to me. I like to reduce or avoid attorney fees, probate costs, and estate planning. Look, for almost, 10, 12 years, I was vice president of legal and compliance for some big companies. And whenever I was creating a contract, I would always here are all the talking points, and then give it over to the attorneys, and they would add the legalese and make it all legal. But I did probably 80% of the work in just clarifying exactly what the parties wanted. That's really what an estate plan is. Here's what we want, and then sometimes we give it to the attorneys to create the legal document that's going to hold up in court. But there's so much that you can do by thinking it through and asking the tough questions. And that's really what an estate plan is. It ensures someone we trust, rather than a court-appointed person, will act if I'm incapacitated and make those decisions. And even when I pass away, it's somebody that I trust. That's why we name them the trustee generally. I want to protect the children sometimes from themselves, and I also want to protect them from from unscrupulous people. So protect the children and the vulnerable beneficiaries is an important thing for me. And most important for me is to make sure that my spouse receives adequate. Oh, there it is. Down that. I've created my trust so that my wife is taken care of first. And then the kids can have the crumbs on the table, but I want to make sure that she's taken care of. And I think for most husbands, as I've talked to them over the years, that really is their number one goal, is to make sure that spouse is taken care of. And then when we get done with that, so a trust can do that, or a good estate plan can do that. So some of you go, well, if I don't have an estate plan, is that okay? Well, yeah, it's okay, because your state has one for you. It's called probate. And let me walk you through what I consider the problems with probate. Here's probate, here's the legal definition, but okay. Legal distribution of your assets upon your death to your heirs is administered by the probate court. Let me just clarify this. It's the process of figuring out what to do with your stuff because you didn't have a written plan. And let me walk you through the problems I see. The average length of probate, according to several experts, is about 20 months in America. The problem with that is that most people in America die broke. And what if we had $1 million worth of assets? And in today's world, $1 million is not a lot when you add in, here's my life insurance, here's the equity in my house, here's my business, here's all my retirement accounts. I add that all together. If most people die broke and the average is 20 months, then really probate could take years. Okay, so that's one of the problems. Another problem is maybe the expense. The expense of probate, generally across the board, I think the average is 3 to 8%. But some states, California, New York, Florida, probate is going to be more expensive. There are states like Utah and Texas where probate is going to be expedited and it's going to be little bit cheaper. But that's okay. But consider putting all of your stuff in one big pile. Everything you own, including your life insurance and everything, all the equity, pay off the debts, and whatever this is, figure 3 to 8% right off the top to figure out what to do with your estate. Why would you have to pay that? The answer is you don't. Probate and estate taxes are 100% optional if you'll use the proper tools in a timely fashion. I don't like the time or the expense of probate. I also don't like everything that goes through probate becoming a matter of public record. No, I would rather not have that. And some states are worse than others. But probate is a matter of public record. It can't be stopped once it's started. And if you own property in 5 different states, your family's going to go through the lovely probate process in 5 different states because every state does it a little bit different. And then there's something else I added this afternoon, and that is probate is really designed to protect the creditors. It was not designed to protect the beneficiaries. Probate comes from Old English law. Hear ye, John has died. Okay. And whoever has a claim against their estate has a certain amount of time to bring all of those claims, all those debtors, everybody. Bring in all the people who were distant cousins who said, oh, but you promised me. Okay, whatever. All the claims against the estate make decisions. But it was really designed to protect the creditors, not the beneficiaries. And then after that time is over, gavel comes down. Yep, okay, all claims against the estate stop. So there is a reason to maybe take one little asset and run it through probate, but generally that's not the goal is generally to avoid probate on most of the assets you have. All right, so let me close out this screen because it's bugging me. And I'm going to put this hopefully over here and put your questions over here. Okay, now I can understand. Okay, there we go. 6 different tools to avoid probate. Let me talk about some of these. One, joint ownership is one way that we can avoid probate. If me and my wife have an asset in joint ownership, and I pass away, very clearly there's clear title to that asset. Whoever is the surviving person gets the asset. There's no probate because there's clear title to it. Really, the purpose of probate is to take all the assets that didn't tie in. I don't know who owns them because John is dead. All those assets that are in limbo and get rid of them. And to whoever, to the appropriate people. Joint ownership, there is clear title to that asset. The problem is that it can create liability for, we consider joint ownership to be kind of the financial kiss of death in a lawsuit because there's an indivisible interest. If I get in a lawsuit, and my house is in joint ownership, can they come take that away even though my wife didn't do anything wrong? Yes, that's what it means. And here, the problem that I see with it is when mom and dad die and they leave an asset to 2 or 3 kids. Now they have joint ownership. They receive the gift. Oh, but one of them has an IRS lien. One of them has a lawsuit. One of them is in the middle of a divorce, and you see that asset goes really fast because each one of the kids have an indivisible interest, and a claim against any one of them could take the asset. So joint ownership does avoid probate, but lawsuit side it sucks. it creates so much liability. We usually don't want assets in joint ownership. We want them in, something. Okay, for every state, there's a state probate shortcut. What that is probate court does not want to see your estate if it's under this level. The problem is that every state has different levels. I think California is up to almost $200,000 unless there's real estate. If there's real estate, yeah, it's going to go through probate. But they don't want to deal with small little estates. Well, okay, 200,000 is a lot, but a lot of your states, that probate shortcut starts at $5,000. And there's multiple states that have a $5,000 limit. Some states it's $50,000. Some states it's 30 or 25 or whatever. And so on small estates, unless there's a dispute, you can usually sign a piece of paper saying, here are the assets, run it through the probate court, and they go, yep, fine, pat you on the head, and you guys go figure it out. We don't want to see you in probate court. That's called a probate shortcut. And you can Google that to see what your probate shortcut is wherever you live. Okay. Then there's POD and TOD, payable on death and transfer on death. Payable on death would be for bank accounts and brokerage accounts. Transfer on death. So I sign a deed in real estate. Some states for a vehicle. Transfer on death. When I die, then, Betsy gets the car. Okay. Or Betsy gets the real estate. The problem with both of these is that they get the car when I die. That sounds good, but what if they're in the middle of a divorce right now? What if they have an IRS lien against them right now? What if this is really bad timing because I owe the IRS a lot of money and you just gifted me an asset? Or maybe they're on Social Security and you gave them such a big gift that it denies their compensation. Oh, that's a problem, because in a trust, you normally would have spendthrift clauses prohibiting the successor trustee from distributing assets if you're in the middle of a divorce, or if, I don't know, lots of different contingencies. The problem is the second you die, they get the asset, and they may not be old enough to receive that gift. There's no spendthrift clauses. There's nothing. If they're just barely turned 18 and they receive something, maybe that's an asset that would ruin them to receive your $1 million life insurance policy right then. Maybe they're not old enough to receive it. So I don't necessarily, I will use payable on death and transfer on death occasionally, but it's not always the best estate plan. For life insurance policies and retirement accounts, there's what's called a beneficiary designation. The problem that I see with these is that we don't update these. I was on the phone with somebody, I think yesterday, who recently divorced. Let's check your life insurance policy. Oh, wait, my ex-spouse. Oh, my first ex-spouse is still listed as the beneficiary of the. Well, let's take off the first spouse and the second spouse, and let's make sure that those are cleaned up and maybe updated. Beneficiary designations, as long as the person is alive and willing to accept the gift, then that works. That's exactly how we avoid probate. There's no need for probate because there's a clear title to who's receiving the asset. The most useful tool for me, these are all useful tools for specific situations, but the most useful tool for me is a revocable living trust. For every person, and whether a trust is important to you or not, every person over 18 really needs, I'm not giving legal advice, but I sort of am. I think every person over 18 needs 3 documents. They need a last will and testament. They need a financial power of attorney, and advanced health care directive. Now, every state calls this something different. Some states it's a living will and a medical power of attorney with a HIPAA release. Sometimes it's an advanced medical, whatever your state is. Number 3, this is a state-specific form. Sometimes even the financial power of attorney, but that's generally across the board that works in most states. But the Advanced Health Care Directive is a free form. You can always pick that up, usually from your state bar association. Every hospital in your state will have one. Every nursing home will have one. Just fill out the state form. But the last will and testament, and the difference between them is the living will, you're expressing your desires. I want to be a donor. I don't want to be a donor. I want my life extended. I want, a certain amount of care, or just pull the plug, whatever you do. And then you're giving medical power of attorney, the ultimate decision-making opinion, in my case, to my wife, where she looks at the living will and she goes, thanks, dear. I appreciate what you want, but here's what we're going to do. The medical power of attorney overrides the living will, but they have to be able to see the medical records to get access before their power kicks in, and that would be a HIPAA release. So all of those things are generally combined into one. There are lots of horror stories that I could tell you, but all of you on the call probably need, as a foundation, these independent documents. Now, if husband and wife, you might only need one trust, but each one of you would need a last will and testament. Each one of you a financial power of attorney. Each one of you an advanced health care directive. So these are kind of critical foundational documents. Okay, let's talk about a trust and what that is. Legal definition is, all right, it's right there. A legal document that creates a fiduciary arrangement allowing a third party, meaning the trustee, to hold the assets on behalf of the owners, which are the beneficiaries. Okay, that's the legal definition. Most of you know I'm not an attorney. I simply train. I've written books. Most of you know what I do. I've run a hotline for 26 years, but I'm not an attorney, and I don't explain things. In my mind, the trust is like your great big popcorn Tupperware bowl. All of you have one, but you never put it in the cabinet empty. You always put all the little Tupperware bowls nested inside, put the lid on, shove it away in the pantry. Okay, that's your trust. Here's what I want. Yes, you might own a corporation. Yes, you might own an LLC. But the stock of the corporation might be titled in the name of the trust, so that when you die, who owns the trust? Well, who owns the corporation? Well, there's clear title to it. Yes, you have a 50% interest in that LLC. But when you die, all your rights and interests are assigned down to the trust, and that 50% interest doesn't have to go through probate. And so and then maybe it owns your house, and maybe we put bank accounts. But eventually, everything you own kind of falls into this big trust, or at least a form of a trust. An IRA is a trust. A 401k is a trust. Some of your life insurance policies and annuities are set up as trusts. So not necessarily this one trust, although we could do that, but sometimes, as long as we're avoiding probate, that is the goal. There's two main reasons I really like trusts. And one is that it can promote family values. Whatever your family values are. Some of you, let's reward the kids for getting higher education. I believe in military service, but they don't pay very well the first couple of years, and so there's a stipend in mind saying, kids and grandkids, if you want to serve, thank you. I love America. Let's serve, but here's a little bit of money to do it. If sometimes a two-family income household isn't making enough, so for my daughters, and Stepdaughters, here's a little bit of extra money if you need to be a stay-at-home mom. We believe in that. If you want to go into the ministry or church activities or whatever you're trying to promote within your family, whatever you can put into writing, you could do this. And now all of a sudden you're creating a bit of a legacy and saying, you know what, we believe in higher education, so here's some matching funds to do that. You see what we're doing was we're trying to promote, not necessarily control everyone from the grave, but we're trying to promote the things that we believe in the very most. And that list is going to be very different for every person, but trusts can do that. Just dumping an asset on a child without any provisions doesn't create a legacy. Okay. Here's the other reason I like trusts, and that they can provide safeguards. There can be age restrictions. I don't want an 18-year-old to get a great big asset, or before they're ready for it. I've got 5 children. Some of them like real estate, are good with real estate. Some of them are good with money. Some of them aren't. If I dumped on one of my daughters a lot of money, it would be gone in a week. She's so charitable. She has such a big heart, but she doesn't control money very well. And one of them is really good with money. One likes the stock market. Those are, one likes real estate. So I can divvy up the assets that I believe are going to benefit that particular child. And then spendthrift provisions. What that does is that limits the trustee or successor trustee from distributing under these situations. So we can control benefits to ex-spouses, or we can control distributions to like special needs children and say you can only provide this much care, otherwise it would disallow their Social Security benefits. Or we could have what's the probate shortcut for New York City? I don't know. You can Google that and find out. It's an easy Google search. Okay, I like the idea of putting a limit on the successor trustees. I've seen so many trustees hold on to the trust for years, never providing any information. Nope. You're going to be a successor trustee. You're going to provide every other beneficiary. You're going to give them a copy of the trust. Or, I'm sorry, and there's a limit on how long you can hold it. Maybe in my trust, it's got to be distributed within 5 years. Well, I've got some real estate in mine. It may not be the top of the market when I die. And so maybe there's a reason to hold on to a little bit, but I want a limit on trustee fees and terms, terms of replacement, where the other kids can gang up on the oldest child if need be and remove them. I don't want this to be a court experience. I want this, I really like a per stirpes clause. Per stirpes is Latin for along the branch. Again, I got 5 kids. Child number 4 has 4 grandkids. Okay, well, I got 4 grandkids through child number 4. Let's do that. If my son dies, do I want to disinherit that branch and now everything is distributed to 4 children? Or do I want my daughter-in-law to receive that inheritance and thus, or do I want a generation skipping clause where I don't want to distribute to her, but I want to distribute to the 4 grandkids? Those are decisions that really need to be made in advance, and we can do that with the trust. Remember, again, a trust is like a good contract. We're anticipating what might happen, and you've got a good attorney that's sitting down and asking you the hard questions and making decisions and putting it in writing long before it happens. That's really what a trust is for me. And some of you are going, yeah, but I have a last will and testament. Okay, that's good. You have to understand something. A will guarantees you're going to go through probate. Well, not you because you're dead, but your estate will go through probate. A will guarantees program, or probate. So it's going to be time consuming. It's going to be costly. It's going to hit all of the things that we talked about. It's a matter of public record. So therefore, it's a fly to the unscrupulous. It's easy to contest a will. Statistics show that 25% of all wills will be contested. And so let's say I've got a trust and it's fully funded. I put the assets in. Do I still need a will? And the answer is yes. I told you everybody over 18 probably needs a will. So even if you have a fully funded trust, do I still need a will? Yes, because the will can only control that which it owns. And I can't retitle the kids in the name of the trust. I can't retitle the pets in the name of the trust. And then the will has what's called a pour-over provision. It looks over, scans over, pours over your estate, and it goes, that should have been in the trust. Okay, let's put that in. If it's a big asset, it might go through probate, but it would be an easier probate because of the pour-over provision and the trust. So we want the trustee privately to distribute the assets, not make it a matter of public record. And then there's a little bit of a legal backup. Okay, so those, we still need a will, but we generally don't want the assets assigned to the will, just that little safety net pour-over provision. Let me show you a slide that maybe will make a little bit more sense. Picture pouring water into a great big bowl. So what we're doing is we're pouring over, we're, again, looking over, scanning over, pouring over your estate and goes, you forgot the china cabinet. Okay, that's in the trust too. And it's looking over all the assets you might have forgot, and it pours them over into the trust. I know that's a weird term, but that's the term. Let's take a minute and answer some questions. Life insurance on the life of the husband owned by the wife because part of the estate upon the... I'm not sure I understand the question, madam. Okay. Susan, does joint ownership of a bank account with an adult open up parents' other assets to a claim? No, just that one asset, Susan. And then, how often should one update the estate planning documents? That's a really good question. Let me put that off because there's a slide on that, and I'll talk about updating and give you a couple tips on that. Okay. Let's talk about the types of trusts that there are. And the attorneys out there create so much confusion. I understand why we're confused, because they name trusts. But most everything you're hearing about trust is a marketing term. Here's exactly what you need to remember is right there in that box. Everything else is all marketing crap, okay? A trust is either revocable or irrevocable. That's it. It's either created while you're living or after you're dead. That's a testamentary trust. Living trust is inter vivos trust. You hear that sometimes. Latin for while you're alive. Okay, so all trusts are either changeable or not changeable. They're created while you're living or after you're dead. That's it. That's all. All trusts are fall into that category. The marketing terms are confusing because you hear, and there are hundreds of different names for estate planning term. The most common I put down here, there's a spendthrift trust, and so we get people call, do you have a spendthrift trust? Well, a spendthrift trust is a revocable living trust that has spendthrift clauses in it, prohibiting the trustee from distributing assets under these certain conditions. But it's all the same until you get to the distribution clauses, and then they put in some safeguards. There's an AB marital trust or a special needs trust. Special needs trust would be for children. There's a generation skipping trust. all of these have a specific clause in them or a paragraph, but all of them are a revocable living trust. Then there's a qualified terminal interest. We call it a Q-tip trust. And we do that for second marriages so that some of the assets are preserved for the assets of the first spouse, and the second, we're preserving the assets for the second to die, and we don't mix those up. That's called a Q-tip trust, or it's a revocable living trust that has a distribution clause with Q-tip provisions. That's all it is. And then there's a domestic trust. Whenever one of the trustors, one of the creators of the trust, is not a U.S. citizen, we have to have clauses in there. Or maybe one of the beneficiaries is not a U.S. citizen. So then now we need Q-dot provisions. There's a Taunton trust, which is not really a trust at all. It's a payable on death deed, but we call it a trust because attorneys can market it that way. And by the hundreds. The most common we hear is a DAP. Well, it's a Delaware Asset Protect. This is an irrevocable trust created while you're alive. There's a Wyoming statutory trust. There's an Alaska. There's a South Dakota. We call them a blind trust. Or somebody calls the office and goes, "Have you heard about the new invisible trust?" Well, yes, I did. It's a irrevocable trust created while you're living. There's offshore trusts, and these protect assets. Okay, and they're good at what they do. I'll talk about revocable and irrevocable in a minute. Then there's tax reduction trusts. There's CRUTs and charitable remainder trusts and CRATs, a charitable unit trust. And CRUTs, there are stand trusts. It's a standard trust, but the attorneys call it a stand trust because it's an acronym that nobody understands. There's a flip trust, a NIMCRUT, a NIT trust. There's so many acronyms in the industry, and there's an ILET, which is it's the darn acronyms, and there's hundreds of these things. And then, oh my gosh, then there's a land trust and a firearms trust and a personal residence trust. And all of these things hold one asset, an RV trust. Have you heard of the Iraqi dinar trust? Yeah, I know. It's a revocable trust, maybe an irrevocable trust created while you're alive to hold one asset. All of these are just marketing terms that hold one asset. And then there's retirement plans. Case they are trusts and traditionals and Roths and simples and SEPs and health savings accounts. And you're going nuts. This is all you'd really need to know is on that little square right at the top left-hand corner. So what we did for the summit is we created a little song to help you. Okay? Cruts and Crats for steady pay. It's a really catchy tune. In case you don't recognize it. ILETs keep the estate tax away. Grats and Q-tips pass with care. Cruts give charity its share. Now I know my irrevocable trusts. Forgetting this song is a definite must. Right there. That's what's in that little circle's all you need to know. The rest of it is marketing crap. Here's what you do need to know is that there are three parties to that trust. Chances are I will probably never, ever, ever sing that song again. Give me a thumbs up if you are grateful that you're never going to hear me sing again.
It's on recording, and we'll put this on YouTube.
All right. Answer some questions. Should a house spouse be on title? John, we'll get to that. How to protect the home, John, is probably one of the most difficult and complicated issues, and we try to cover that at the summit. But could a spouse be on title if it's protected? So if you live in Texas and Florida and there's 8 states that protect the homes really well, great. So put spouse on title. But if I live in a state like Alabama that does a really sucky job with homestead protection, oh, yeah, they might protect the first $5,000 equity in your home. We would put it maybe in a personal residence trust first, and then, and we hide I don't know. So it's a complicated question, and I don't know how to answer it. So, John, Maryland, I don't know your homestead in Maryland. I think I don't know. I don't know. Okay, so the parties, here's what you need to know about trusts. Oh, wait, one more question. Gary, if all my assets pass through transfer on death or payable on death, except for the personal possessions in our house, does the will still go through probate? No, if all the assets are under the probate shortcut, and Gary, personal assets tend to get lost. And they don't go through probate because, I don't know, whoever gets to the house first tends to take the china that they want and the wedding rings that they want. And they generally don't get, I'm not saying it's a good idea, but if everything is going to avoid probate, the purpose of the trust is to help you avoid probate. And if we can do it with transfer on death and payable on death and the other methods that I said, then maybe we don't need a trust. So on small estates, especially where there's no real estate involved, that would be very common. Anonymous asks, can I name an attorney as the trustee if my initial trustee is no longer available? Yes. In fact, you'll generally list several people in succession. Hold on to that. Dinar is spelled D-I-N. Oh, I'm sorry about that. I think I knew that, but somehow I misspelled it. Thank you. Let me get to successor trustees in a minute. Okay. Let's go on. Now that I've sung my little song and you're all bored to death, so here's the three parties to a trust. There's somebody who creates, drafts, and funds the trust. There's some technical differences, but it's the grantor, the trustee, or the trustor, the settler. That's how they're legally defined. We're just going to call them the trustor, the grantor. The settler gets complicated. Okay, the trustee is the person who controls and manages and distributes the trust assets. And then there's beneficiaries. They're the people who receive the benefit from the trust. And sometimes in a revocable living trust, you get to be all three. But you have to recognize what you're doing at the time and use the proper title. Let me scoot over here for a second. Years ago, I created a whole bunch of hats. One for limited partnerships, one for corporations, but here's my three trust hats. There are times when I'm creating, now I'm the trustor, and I'm wearing this hat to create the trust. I'm the trustor. And whenever I redraft or amend, then I'm acting as the trustor. Most of the time, once the trust is created and funded, I don't need to wear this hat anymore. Chuck it away. Okay. And now I'm acting as the trustee. And this is the person who controls, manages, distributes, but I never act as a beneficiary except to receive. I would often act as the trustee. But the trustee doesn't create and redraft things, just I manage things. That would be the role of the trustee. Then, someday, somebody, and maybe it's not you, maybe it's the contingent beneficiaries. I know that these are just technical terms, but trustees and successor trustees, beneficiaries and contingent beneficiaries, I know it's semantics, but that you probably ought to know the difference between them, okay? That's the person who receives the benefit from the trust, and when all the trust assets are distributed and it goes away, then your role as the beneficiary goes away because there's no assets. I hope that makes sense. Okay. Let's talk about revocable versus irrevocable trust, because we get a lot of questions, and we've had a lot over the years about, because there's a lot of people that are promoting irrevocable trusts. Almost every time that I'm talking about trust, I'm going to be talking about revocable. I like things that are changeable, because life changes, and new kids are born, and new grandkids are born, and people die, and people get married, and people get divorced, and life happens. There's emergency things that happen all the time that change. I like the ability to change and revoke. The asset protection rarely enters into trust thinking. We use limited partnerships, we use corporations, we use LLCs to protect assets. Trusts, we generally don't use them as an asset protection tool. We're really talking probate tools. And I like holding assets in limited partnerships, LLCs, corporations. That's your business entities. But right now we're talking about the foundation, which is your estate plan. I like the ability to change and revoke. And I'll give you some examples when I might use an irrevocable trust, but it's very selective. I don't need a revocable or a tax ID number or a tax return for a revocable living trust. On an irrevocable trust, it most likely will be required. When I set up and fund an irrevocable trust, most of the time it's going to require a tax return and a EIN number. Irrevocable trust or revocable trust, for me and my wife, when both of us die, then that trust becomes irrevocable. But I'm not setting it up initially. Right now, my trust is a revocable living trust because it's flexible and my kids are still making dumb decisions and they're growing and learning from their own mistakes. And and they're still having kids and I'm having grandkids and maybe next month a great-grandchild. Okay, so life continues to evolve. So I like revocable trusts that someday it will be irrevocable, but not now. The income in a revocable living trust, all the assets, because the revocable trust is disregarded by the IRS. The IRS doesn't care that it exists. Whoever is the grantor, me, gets all the tax. If it makes money, then I made money, and it shows up on my individual 1040. It doesn't need a separate tax return. However, income out of an irrevocable trust, I usually, because irrevocable trusts have the highest tax rate, I almost always want to distribute all the income generally, because it's going to be taxed at trust rules, which is like the highest tax rate possible known to mankind. And so I generally don't want to leave money in an irrevocable trust and let it be taxed there. I want to distribute it if there is money. On a revocable trust, it doesn't matter because it doesn't exist as far as the IRS is concerned. The revocable living trust has zero asset protection. And an irrevocable trust, it could have good, strong asset protection, depending on how much control you're exerting over the trustee. On an irrevocable trust, you can't be all three. Generally, there's exceptions to every rule, but generally you can only be two of the three. So I created the trust, I get the benefit, but somebody else has to manage it, is the way most irrevocable trusts set up. But if I start calling the trustee anytime I want to and say, hey, I need $10,000. Well, that's not according to the terms of the trust. I know, but just give it to me anyway. And so he does. He writes you a check out of the trust and you get money. And anytime, if you're using that trustee as kind of your personal piggy bank to get money anytime you want, then you've really messed up your asset protection. And so people call me and say, I've got an irrevocable trust. It's great asset protection. Can you get money anytime you want to? Oh, yeah. Yeah, Fred's my friend, and he just gives me money whenever I want. Well, then you can't expect that to be strong asset protection, can you? Because it's not a personal piggy bank. And then a revenue ruling right at the beginning of 2023 said if you've got assets in an irrevocable trust and you die, most likely the kids don't get a step up in basis, so you're creating a capital gains problem for them in that they receive your basis and they get to pay capital gains taxes someday when they sell the asset. Now, I'm giving you a general rule, and there can be provisions. Again, there's exceptions to every rule, and I'm giving you some basic rules. Most of the time, if you've got assets in a revocable trust, the kids automatically, everything is reassessed at the time of your death, and the capital gains tax, the capital gains goes away. There's no tax. In an irrevocable trust, that is not the case. I hope that makes sense. Basically this, a revocable trust, you retain control and ownership because it's disregarded. As a result of that, you get no asset protection. On an irrevocable trust, you're surrendering ownership and control, and now you have to follow the terms of the trust. On an irrevocable trust, once you create and fund that trust, you've poured wet concrete and you're not getting that back. Okay, on a living trust versus testamentary trust, and I've got to go a little bit faster. I'm sorry, I'm telling maybe too many stories. Living trust is created while you're alive. It's created by you, the grantor. The testamentary trust, you're dead. Sorry, it's created by your executor. Remember, wills have executors. Trusts have trustees. I know that's semantics again, but there you go. Living trust is created and funded while you're alive. The testamentary trust, after the probate process is all done, or during the probate process, then the trust is funded after your death. So therefore, those assets are going to go through probate to get to that trust. Well, why would you do that? And when I teach case studies, I always show a small estate. And here's, mom and dad were really healthy, and we didn't think we needed the testamentary trust. We gave somebody we trusted the power to do this if we, in the event that we died, but we really didn't want to go through the legal expense of creating a trust right now, so you created testamentary trust. Sometimes there's a need for that. So you pay for the living trust while you're alive. The testamentary trust, it's paid for after you're dead from your estate. How do you fund a trust? Well, what is the minimum amount? Let me read a question. What is the minimum amount of estate that you should have to have a trust? That is such a good question, and I don't know how to answer that. And I've heard people say, in fact, who is it? One of the TV or one of the radio shows says, unless you've got $2 million, I wouldn't even create a trust. I don't subscribe to that because there's so many things I can do on a small estate. I want these assets to go here. I want there to be spendthrift clauses. So that's a really personal question. And I don't know how to answer that, but if you're under the probate shortcut, or you can get there with some really simple tools, you maybe you don't need a trust. And Marciela, did you say trust controls, manages, distributes assets, but does not receive the benefits? No. The trust, you could be the trustee and you could be a beneficiary. Remember, in all trusts, revocable trusts, you can be all three. Irrevocable trusts, you can be two of the three. If so, am I precluded from identifying one of my children as the trustee? No. In fact, you probably will name children as trustees, successor trustees. I'm the trustee all the days of my life, and what I've done is I've picked two of my 5 children to be co-trustees in the event that my wife and I are gone. I like the stability of having co-trustees. So nobody, I don't know, I just think it's safer to do that. Can I display the previous slide if I miss something? Let me go back. Is it that the slide you want? I hope it is. Okay, I'm going to, you know what, this will be recorded, and so you can go back if you'd like. But let me move on because I got a lot to talk about. How do you actually fund the trust? So I've created the trust, and let's say, I don't know, it's 40 pages long. Here's the babysitting instructions for when I leave home. But now I need to put the assets into the trust. And I would go down to the bank and use their little form. I guess you could write a letter, but generally we go to the bank and we retitle the bank account. And how do we know that it's been funded? When the bank statement says no longer has your name. In my case, the bank statement says Don and Tam Pendleton, comma, trustees of the Pendleton Family Trust. It says that not on the checks, but it says that on the bank statement. A brokerage account. That statement comes in the mail, and it says Don and Tam Pendleton, comma, trustees of the Pendleton Family Trust. So the trustees are technically the owners. The trustees, the trust owns it, but the trustees are in control. On personal property, we can do an assignment of interest on the big stuff, like vehicles, grand pianos, wedding rings, those things. We could do a personal property memorandum, an assignment of interest form, assigning those assets, and then we always have what's called a Schedule A. After the trust is created, the Schedule A is like the inventory list of what the trust owns. If you've got a life insurance policy, sometimes what we do, especially if you got minor children, my life insurance policy lists my wife as the contingent. She's the primary beneficiary, but the trust, I listed the trust as the contingent beneficiary, so that then all the safeguards and family values and everything, that whatever life insurance money will go into the trust. Retirement accounts, we could do the same thing, except my IRA is set up. I'm the primary beneficiary because it was set up for my benefit when I die. My wife is listed as the contingent beneficiary, and then what we did is we listed the trust as a second contingent. You don't have to do that. Remember, a retirement account is a trust, but you could tie it in, and that way the family values, all of the spendthrift clauses, the safeguards still apply. In addition to retitling the assets, so we retitle everything, but then the Schedule A it should be a complete inventory list of what the trust owns. So one of the questions was, how often do I update my trust? Well, whenever the assets change. And when we do that, we don't necessarily update the trust. We might just have to update the Schedule A. And every time we, change assets, we added a new LLC, we added a new corporation, maybe, I don't know, we had a child or a grandchild or something, and so we change. Sometimes, if it's just the assets, we just change the Schedule A. We don't have to revoke the whole trust just because we had a grandchild. Okay, hope that makes sense. I heard a trustee's job is very difficult. Is that true? Well, it depends on the trust. If it's a really complicated trust, but hopefully yours just has some simple distribution clauses. It's as complicated as the creator of the trustor made it. Hopefully it's not. Do brokerage accounts in the trust with appreciated stock get a step up in basis? Okay, we covered that, Robert. All the assets in a revocable living trust get a step up in basis upon your death. Yes, okay, so the brokerage account is owned by the trust or goes to the trust. Yes, so the answer is yes. Okay. Now, this is an important slide, and I want you to know that, because let's say I create the trust and I fund it, but then maybe I didn't fund it properly. I don't care what the will says. I don't care what the trust says. I care what the deed says. what it says on the bank account, what it says on the brokerage account, what it says on the title to the property. That's what really matters, because the title trumps anything else. It trumps your very best intentions. Well, I wanted to put it into the trust. Well, but the deed matters. Well, I promised my grandson, the 1965 Ford Chevy. I don't know what Ford Chevy. Oh my gosh, the Ford Mustang. Okay, so verbal promises. What do you say, Kendall? The Ford Mustang. That's it.
There we go. I like it. The Ford Chevy.
Whatever you verbally promise doesn't matter. What's in writing matters, and whatever it says on the title or the deed trumps everything else. And so that's why funding was so important. The last will and testament, it doesn't matter what the last will and testament says. It matters what the deed says. Who owns the bank account? Well, I don't care what it says in your revocable living trust. If you didn't put the asset in to the revocable living trust, the trust cannot control. The trust can only control that which you put into it. And that's why the funding documents are so absolutely critical. And let me tell you a dirty little secret that attorneys probably don't want you to know, because over 90% of attorneys, when they create a trust, never fund them. So you paid good money to have them create the trust, and then back on page 61, it says, oh, by the way, here's a quitclaim deed. You probably ought to run this down to the county recorder and put your home into the trust, but you never do it because you didn't read page 61. Therefore, the home is still in your name. When you die, now it's going to go into limbo, which means it's going to go through probate because the attorney didn't put it into the trust. Why did they do that? Well, partly maybe to save you money on legal fees. We told them on page 61, it's right there in writing, but maybe it's also because they get to walk that estate through probate. Oh, so you paid them to create the trust to avoid probate, but they get to walk you through probate and double dip on your estate. Do you see the little game that they're playing? Don't do that. When you create a trust, we make sure that we fund it. And then in addition to retitling the assets, the Schedule A, again, is a complete inventory list of what the trust contains. About 3 years ago, I posted something on social media, which is really rare for me. But this is something that I feel very, very strongly about. Being open and honest with your children can be the best way to reduce family tensions. While you're alive, it's far better to explain your plans before your death than to create estrangements and hurt feelings after you're gone. I really strongly feel that way. Okay, now we create some of the problems and the misunderstandings about trust, because when we talk about a trust, sometimes we're creating some of the mess. A trust is a lot more than just the trust document. When you're paying a good attorney to create a trust, yes, there's a trust document. Let's say it's 40 pages long. But then there's usually a Schedule A. Here's the inventory list of what the trade trust has. And then there's a personal property memorandum, which is, but the rose-colored china goes to Betsy, and the china cabinet goes to Fred, and I don't know, whatever. We list these assets go to a specific person. The artwork from great-grandma, okay. And so that's called a personal property memorandum. And then there's an abstract of trust or a certificate of trust. And what that is, it's a condensed Cliff Note version. Yes, you got 40 pages in the trust, but just the 2 pages that the bank needs to know. Because when you go down to the bank and say, I'd like to transfer my bank account into the name of the trust, they're going to want to see a copy of the trust. And you're going to go, no, eat dirt. You're not gonna get a copy of the trust. I'm going to give you the Cliff Note version. That's all you need to know. Everything else is a private document. Oh, Well, that's all. Well, yeah, you're right. That's all we needed to know was the certificate of trust. When you go to the county recorder and say, I want to transfer my home into the trust, they're going to say, well, we want to see a copy of the trust. And you're going to go, nope, eat dirt. Just here's the certificate of trust. That's all you need to know. And then there's funding documents, and there might be a quitclaim deed. It might be a warranty deed. In your case, I don't know, there's a difference. There might be a letter to the bank account or the brokerage account, or frankly, just use their form. There might be an assignment of interest. Yes, I've got an interest in this LLC, but I'm the member all the days of my life. Upon my death, I want my interest assigned to the trust, or we could do that with a corporation. We assign your interest. We do all those things. That's called the trust. But then there's a financial power of attorney. In most cases, for estate planning, we want it to spring into action upon your incapacitation. We want it to be durable. It's effective even in incapacitation, and it has a HIPAA release. And powers of attorney usually begin at incapacitation. It could begin anytime, but estate planning ones, they spring into action, and powers of attorney always end at death. And now the trustee or the executor or somebody takes over. Then we also have the last will and testament that has guardianship provision, a pour-over provision, all of the other things, the account numbers, your passwords. There's an advanced healthcare directive. It has all of those things in there. That's what we call the trust. And I know that I know that's not accurate. I know that we're creating confusion because it's a lot more than a trust, but it's really your complete estate plan. But we lovingly refer to this as the trust. Make sure when you're buying a trust that this is really what you're getting. And every state might call a couple of these documents just a little bit different, but this is a trust. And so when you're at our 3-day summit, we often say, here's Anderson Business Advisors. They do trusts in all 50 states. Here's their price to do it. I think it's $8,000, and then they discount it for our students. If you would like a copy of them and just to do it, they're the best attorneys that we know that work nationwide. If you're interested in that, you can sign up and do that, and that offer is still good. Okay, so let me go back to this. That's what we're talking about. When we're talking about Anderson's trust package, that's what we're talking about. And yes, they call it a couple different things. There you go. But that's really what it is. Let's take a second and answer some questions. If all my assets are left to various charities, is it sensible to appoint an attorney rather than a family member as a trustees? Okay. Attorneys are going to be unbiased. Most of your banks are going to have a trust department. They are going to be unbiased. They're going to fill out all the paperwork. They're going to run everything. They're going to do it right. But they're going to be the most expensive. And so what I see often is there's several people listed in succession. I want, Jane and John to be the co-trustees. But if they're not available, then I want Paul to be. And if he's not available, I want Renee to be. And so we're listing people in succession. And generally, the last person on succession is Zion's Bank Trust Department or this attorney. Now, you don't have to do it that way, especially on large estates where you know there's going to be disputes. Just take the ambiguity out and list an attorney or a trust department. And again, that's going to be the most expensive, but it's going to be blind. It's not going to be ambiguous. It's not going to be tainted. Hopefully, it's going to be very fair, but you get to decide. So hopefully that makes sense. Robert, do you need to retitle property that is currently in a family limited partnership or an LLC into the trust? No. Keep it in the family limited partnership or in the trust and just assign your interest to the trust. So let's say you own at 80% interest in that family limited partnership. But then we use what's called an assignment of interest. You're the partner all the days of your life. Upon your death, you want to assign your interest to the trust, or to another person, your son or your spouse or somebody. But if you don't do that and you die, that 80% interest is going to go through probate. Or you have an interest in an LLC. I own 50% of this. You're the member all the days of your life, but upon your death, you want that there's an assignment of interest. Some attorneys will call this a designation of successor in interest form. You're designating the successor to your interest. I don't care what you call it, but you are assigning that interest. So generally, you're the member or the partner all the days of your life, and you assign that. Robert, but don't retitle the assets. Leave them where there's protection. What is an acceptable trust administration fee, especially if it's irrevocable? Takes 3 years to complicate. I don't know. It depends on your state. If you live, for instance, in California, it can be as much as probably 7% of the trust assets. And other states, it's often regulated by your state's. What is it? I don't know what department regulates it, but what's average? It really depends on your state and the complexity. But I would say 3 to 8%, maybe 10, depending how complicated. Winnie, good to see you. I missed you down at whatever we were going to. Anyway, if you get a TIN number for a revocable trust, so it's probably an EIN, and it isn't in your name, does that protect your assets? Winnie, no, it's revocable. So you can get an EIN number for a revocable trust. It's not in your name, but because of the fact, revocable living trust, Winnie, because you can move the assets in and out, in and out, in and out, because you always have access to those assets, therefore a judgment creditor would also always have access to those assets. It's revocable. It's amendable. You have access. You could take them out. Therefore, there's no asset protection. Anonymous, whoever you are, do you need to include retirement accounts and mutual funds into a revocable trust? If you listed beneficiaries, no. A retirement account, as long as a retirement account is a trust, and we don't have to dump that into a revocable trust. The example that I used, especially if you got minor children, I don't want minor children receiving a retirement account. I would want that to be me, my spouse, and then I put that into a revocable living trust. But that's that's a personal decision I make. Certainly, most people don't do that. They just list beneficiaries in succession. Can any of the steps in creating a trust and an estate trigger a tax event? Well, upon your death, it might. You know what? I've got a slide coming up here. If I get to it, and I'll answer your question. One more question here. I had to place my home mortgage note back to my husband and my name to be approved for a HELOC. Can I put it back into an LLC, which is owned by the holding company? Yes, I'm not sure, Virginia, the whole thing. You also have a land trust. You're asking a question I don't have the background to be able to answer. So maybe call the hotline when I'm in next, not this week, but next week, and I'll be able to help you. But I need more answers. Okay, so let me finish a last few little slides. There are sometimes, I believe in doing some of my own legal work, but there's times when I don't want you to. If I've got a large estate and it's complicated, if I've got special needs children, don't do this yourself. I don't care. There's too much to lose. If I want unequal distributions to kids, I probably wouldn't draft that myself. Second marriages and blended families and limitations If I really want limits like drug use or criminal activities, out of faith marriages, if I'm putting limitations or conditional distributions, I would probably get some help on that. Customized incentives, disinheritance. I want a child or a grandchild to be disinherited. I would make sure that I'm doing this right. Non-resident grantors, remember we talked about QDOT and QTIP provisions, spendthrift provisions should be in all trusts, but how complicated they get, I might need some drafting help on that. Generation skipping clauses, I like having those. Maybe it's appropriate, maybe it's not. Whenever your revocable living trust is going to be the beneficiary of a IRA or 401k, that trust needs special provisions in it, or you're going to create a taxable event there. States right now that are subject to estate planning or estate taxes, I would, anything close to that, I would make sure you're not doing your own trust. Limitations or compensation for successor trustees, I like a little help. Look, there's, and here's what I was getting to. If you live in one of these states that's shown on this map, the states in purple have an additional estate tax. For instance, if you live in Oregon and your estate, everything, including life insurance, is over $1 million. I know there's no federal estate tax, but there's a state estate tax. And then if you live in one of these states like Nebraska and you inherit something over $100,000, that was your inheritance. There's a tax on that, and it'll range from 1% to 5%. And so if one of your kids or one of the beneficiaries lives in one of these blue states here, and we're not talking politics here, we're just on the map, then I might distribute slowly over time so that we never hit that cap and never create an annual cap, and we never create an inheritance tax for them. Do you see what we're doing? Sometimes it's very custom to what your kids are doing or how big the estate is. And then there's any time we're complicating this, anytime there's irrevocable. Look, I've been teaching tax and legal for 26 years. There's times, set up an LLC, I can do that in my sleep. Set up a family limited partnership, an irrevocable trust, there's no chance I would ever do that myself. Because again, you're pouring wet concrete. There's a few assets I don't want you to put in a trust. Qualified retirement accounts should not initially be put in. They could be a contingent beneficiary, but the rule is a trust cannot own a trust. It can be a beneficiary, but it can't own. Annuities, generally we don't put into a trust. Timeshare commitments, we usually don't protect them in LLCs. Nobody really wants your timeshare. It's generally not worth it. You have to pay to get rid of it. Life insurance policies, again, we don't put them into the trust, but it could be, the trust could be the beneficiary. But whenever you're doing that, make sure we're getting a little help. Vehicles, we don't put it in. And then tips for maintaining your trust. Create the trust, expect that it's going to change. And my feeling is at least annually, you ought to maintain it. Who does a Roth IRA go to when the owner dies? Well, whoever is listed as the contingent beneficiary. And so a Roth IRA, you're the beneficiary, but then you should have contingents and maybe several in succession. Can I assign an LLC membership? Yes, Sharon. What I would do is if you own, let's say, a 50% interest, we do an assignment of interest. That would be in the operating agreement of the LLC. If not, you can amend and add that. It's an assignment of interest clause. Upon your death, you want all your rights and interests to be assigned to, and there's a blank line, and you fill it out, and it could be your trust, or it could be an individual, but that's how you would do it. Will that give me some degree of asset protection? The trust does not protect assets. The trust is a probate tool. And then I'm going to kind of conclude with this. And it's a little cartoon I've used often for the last 4 or 5 years. And if you can't see, if you're listening in, it shows a cartoon of an old man standing next to his son. He's in a walker. He's opened his garage door. Clearly, he's a pack rat. And he's saying to his son, someday all this is going to be yours. And so one of my concluding remarks is, let's be clear, your kids don't want your stuff. If you've ever cleared out your mother-in-law's house or your parents' house, or you help somebody move, I don't want your stuff. The kids don't want your stuff. If your stuff is your legacy, you've got a problem. As much as we've always talked about the trust, and up till now, that's what we've talked about. But in my mind, just as important is a personal history. Childhood memories and the important things you've learned in life and your family traditions. That's your legacy. It's your health challenges and your important records and maybe your genealogy. Those are the important things in life. And yes, stuff is important, and don't create a mess for your kids. But that's not your legacy. Your legacy is so much deeper. As you're creating this estate plan, make sure that you're passing on the things that you've learned, because you're really not just creating an estate plan. You really are creating a legacy that can guide and inspire generations. This was another one of our little social media posts that I absolutely love. I believe in. This is what estate planning is for. If we can help you with this, again, Protect Wealth is not a law firm, but there is a law firm that we do trust, and that would be Anderson Law Group, and they are giving our students a discount if you're interested in having them create the entire estate plan. What about jewelry and heirlooms? Okay, let's go back. That would be listed on the Schedule A. And sometimes we take a picture of this wedding ring, and then we list it on the Schedule A. Sharon, sorry, I meant while I'm alive. I'd like to get the asset out of my name and fund the trust with it. Kendall, what asset were we talking? We've answered too many questions. What was the asset we were talking about, Sharon? Maybe, I don't know. I think you talked about putting something in an LLC. Oh, an LLC. So keep all the assets in the LLC. That's your asset protection layer. And then, as all you're doing is you're not moving the assets out of the LLC. You're simply assigning your interest upon your death. You now, whoever now owns your interest in the LLC, and that's how we would. I hope that makes sense. Okay. Kendall, what other questions do we have? Is there anything else we can help students with?
I think one of the things you knocked on pretty well was why not do your own living trust. I thought that was really good, because one of the arguments we found a lot of times was when people do their own living trust, well, and someone disputes it, well, sorry, buddy, you did your own trust, and that could be, a lot of holes could be poked into that pretty fast, and they could be come into question because, was this really done properly? And there's an argument that's against doing it that way, and at least have an attorney look over it at least.
You know what? When I was first married, we had 2 or 3 little kids, and I used a fill in the blank trust, and it worked. Well, I don't know if it worked because I didn't die, but I think it would have worked. For years we've sold fill in the blank forms that work. But then my kids got a little older, and one of them had medical problems, and one was good with money, and pretty soon 2 or 3 had graduated from college, and the others hadn't, and all of a sudden life started to get a lot more complicated. And then one of them got a divorce, and one of them got now a second divorce, and now we start having kids and grandkids, and there is not a chance I would use a fill in the blank trust form anymore. I just wouldn't believe it. I wouldn't do that. That is not the legacy I want to leave. I want to make sure that the trust is created, it's very clear, and it's properly funded. That's the legacy that I'm trying to leave. Is there ever a time for a fill in the blank form? Uh, Perhaps when life is simple and there's not going to be disputes, but not okay.
And as far
Jen,
as
oh, it's
cost
good to
goes,
see you
Don,
on.
I
What's that?
understand as far as cost goes, there are a few questions about cost averages. The thing is sometimes, Don, you've been sent someone's trust to look at it in the past, working with attorneys, and they paid 40, 50 grand to do a
Oh yeah.
trust by some attorney. When Anderson does it here for $4,500, it's a great deal. And remember the one that was about $50,000 to do? The attorney didn't even fund it,
Yeah. Yeah.
and it happens a lot.
And one of the things I like about Anderson is that they're offering an unlimited living trust. So, which means for a lifetime, they'll go back and redraft or amend anytime. So, add on an attorney. See the little bonus down at the bottom? This is unlimited amendments to your trust for lifetime. I don't know any other law firm that does that. Are you kidding me? So it can change as often as you want it to change, and they'll continue. I like that. Okay, Jen, can you assign your living trust interest to 5 different beneficiaries as 20% each? Yes. Each to 5. So the beneficiaries are their 5 living trusts. Yes, I guess technically you could. To be held as members of a new multi-member LLC. I don't know that I would do it that way, Jan. I would make the trust. I would make that multi-member LLC be the primary beneficiary, and then but I think it's
Complicated.
I think you're complicating this.
Yeah.
But if all 5 of your kids have their own revocable living trust, and they are the trust until they die, making the child the beneficiary, not their trust, would be the appropriate way to do it. And then they can put it in their trust if they want to. However, I have seen it done differently. I've seen all the beneficiary of your trust is their irrevocable trust and their family foundations and their and it goes directly into their estate plan. I guess there's pros and cons to that. Generally, the kids become the beneficiaries, not their estate plan. I hope that makes sense. All right. Are we? Oh, we are now exhausted our time. What we usually
On the
end
money,
right
Don.
at the
On the
top
money.
of the
That was
hour.
perfect.
Wow, how about that?
And if you do want to sign up for the trust, we did put it in the chat. You guys know the drill. You can click on that link. It'll take you right there. That is the Anderson discount you won't find anywhere else. That's especially for us.
Yes, and so Virginia, the Schedule A is just an amendment. And here's the inventory list of what the trust owns. And if the trust doesn't change from year to year to year, maybe the only thing that does is the Schedule A. And every time I change it, I would go down, get it signed and notarized, and attach it back to the trust. But it doesn't have to be more complicated than that. But whenever but I can redraft the trust, but I generally don't do that. Annually, I just look at the Schedule A and redraft that as needed too. Okay, Virginia, thank you for being on. And students, we appreciate you being here. This has been, I hope we didn't keep you too long. East Coast time, it's a late night, so thank you for being here. Thanks for your patience. And take advantage of this if it's going to bless your life. And if not, I hope the information was very helpful. Thank you for being here. Make a legacy. Love your
Thanks,
family.
guys.
Take care and have a great night.